Good afternoon, everyone. Thank you for joining us today for ACLA's Lunchtime CLE, hosted by CAPS. I am Bradley Hargis, the Executive Director of CAPS, and we are very fortunate today to be joined by a great attorney from our community, David Frank. David is going to be talking to us today about custodial interrogations and the two-step technique. Many of you probably know David. He's a local attorney practicing here since 1993. He's board certified in criminal law, and he's devoted his practice to criminal, had great success in our trial courts, and had some appellate victories too. So he is a great speaker Betty has lined up for us on this topic, and I'm going to turn it over to him. And he did ask for any questions you have them, put them in the chat, and I will call them out as we go. And as a reminder, if you are watching this live, CAPS will take care of turning in your CLE for you. If you're watching this on a recording, the CLE number will be at the end of the presentation, and you need to report the CLE yourself. All right, thank you. I'm going to go ahead and turn it over to David.
Well, thank you very much, Bradley. I'm happy to be here today, and I'm glad that folks are showing up for these great seminars. When I first started out, Judge Aguilar asked Herb Evans if he would start a program like this with continuing Friday CLEs, and Herb recruited a bunch of local lawyers, and I went to just about every single one of those seminars and learned a lot from some of the best lawyers in town. And I'm glad that Betty has continued that tradition so that local practitioners and these days people from anywhere in the country can come in and give us a talk on Friday and share their experiences. I wanted to do just that. When Betty asked me to talk, she said that you can pick any topic you want. And I thought, well, you know, I happen to be working on two cases right now, which presented some interesting Miranda issues. And I developed those issues, I litigated them in court, and I found that a lot of the things that people had been telling me about Miranda were just wrong. I'd heard that, you know, there's no point in litigating Miranda issues because Miranda's dead. There's no relief. The facts of my case are such that Miranda is the least of my problems. And I think people just tended to stop thinking about their cases in terms of whether or not their clients' statements came in or not. Well, the cases that I worked on actually had an interesting component that I had never really worked with before. And it had to do with a two-step interrogation technique. And the two-step interrogation technique is an attempt on the part of some police departments and police officers to try to do an end run around Miranda, to try to circumvent the requirements and what the rule requires. And so I dug in a little bit and I found that there was some relief, and we got relief on those two cases. And I wanted to talk a little bit about those cases, talk about the rules that apply in Miranda, talk about how you might be able to spot some of those issues and develop them for your cases, and then talk a little bit more toward the end about this two-step interrogation technique. So I'm going to introduce that technique by, let's see if we can get this to go. As far as what it is, the two-step interrogation technique, as its name suggests, has two steps. The first step is that law enforcement withholds Miranda warnings until an arrestee confesses. And so there's a lot of times we see on these videos where the police are just walking up to people that they have in custody and they start asking them questions and no Miranda warnings are given. And if the person does ultimately confess, step two engages where the police provide Miranda warnings and elicit a second confession, this time a Mirandized confession. So there's two statements to be concerned with here. One is the pre-Miranda statement and the post-warning statement. Both of them are going to be important. And the courts have looked at this and they've talked about this two-step questioning technique, and they said it's the intent of this tactic to obtain a confession before the suspect understands his rights, and then read the suspect his rights, and finally have the suspect repeat the confession. And you're going to see some footnotes in this presentation, and that's because the notes within the slides have some case citations, and I'm happy to share this with anybody who's interested in it and wants to learn more about it. So the first case that came up that I was working on was a case involving a DWI crash. And the troopers, or actually I think in this case it was APD officers, found an abandoned car on Mopac, and the airbags had deployed and the doors were open. The car had sustained some damage. It was a pretty bad collision, only there weren't any drivers or occupants in the vehicle. And so the police started looking around, and inside the vehicle, they found some alcohol, and they found other evidence that this was perhaps a DWI investigation in the making, which also had a collision. But they didn't have a driver, and wheeling the driver was going to be an issue in this case. And so they knew that the drivers couldn't have gone far, or the occupants. And the goal here was to try to find those people before too much time had passed. So the police show up, they have some backup, and sure enough, within just a short amount of time, they find further on down the road, their suspects. And they took their suspects and they put them in first they pat them down and they do a search, and they have them sit in the patrol car. My client in particular was sitting in the patrol car with her wallet on the floorboard. They took her phone, even though she was insisting that she wanted to talk to her sister at the time. And the police said, there'll be plenty of time for that later, but we'd like to talk to you. Now, they didn't give her any Miranda warnings, and they knew right away that they had to wheel the driver. She was one of the suspects that they had detained. And they start out without giving any Miranda warnings with, who's the other guy? Who's that guy you're with? And she responds, he's a close friend. And the officer says, what happened? She responds, I was driving and I checked my phone because my mom called and I just hit the side of the wall. So throughout the presentation, I'm going to highlight some of the statements that get made that were incriminating. And we're going to look a little bit more closely at what the questions were. But in this case, there was an unwarranted statement that she admits to driving and that she was the one while driving who caused the accident. So the police now realize they've got some statements that they'd like to use. This is going to be critical for a DWI. It's the essence of the case. And so they go ahead and they give her some Miranda warnings. And they ask her if she understands. They ask, do you understand this? She says, a little bit. And they say, so what happened? Tell me. They're asking for the repeat of the first unwarranted statement so that they can use that now sanitized by Miranda so that they can show that it was voluntary. She repeats it. She says, I was already driving home. And they say, how did the wreck happen? And she says, I just looked at my phone real quick and then it just happened. So in this case, it was real quick. They identified the driver. They asked the driver questions. They elicited incriminating responses, and she gave them incriminating responses. Then they clean it up by warning her. They give her the Miranda warnings, and they have her repeat what she just told them. The question is, did those Miranda warnings do anything? Were they effective? Because after she'd already given a statement, and then after being Mirandized, continuing the same statement, the courts have looked at that and said, some people just won't really understand that their prior statement won't be used against them, and that the continuation, the post-warning statement, is just a continuation of that unwarranted statement. The second case was a little bit more complicated. And in that case, a trooper was driving down the road and saw a white truck change lanes without signaling. And he quickly starts pursuing the vehicle, but the driver of that vehicle tries to flee. So he's now got that driver for evading in a motor vehicle, but the trooper never sees the driver. And so identity is going to be an important issue in this case. And as the trooper turns around and starts chasing after the driver, the truck crashes into a house and the driver flees on foot. And what this looks like, this is an actual photo from the case, the truck crashed into a house. And the driver, the defendant, ultimately the defendant later But the driver at this point flees the scene before the trooper can get to the house. Again, the trooper doesn't have an eyewitness, doesn't know who the driver is, can't identify the driver, just knows that this truck was involved in the fleeing, in the lane change, and now a more serious charge perhaps of driving into a house, striking a fixture along the side of the road. So they do what any good trooper would do, and they go into the glove box and they find some paperwork and they identify someone whose name appears in that paperwork, and they immediately start connecting that person as the driver of the vehicle. They put out a be on the lookout, a BOLO, and the driver is found by 4 police officers. They don't know if it's the driver. They just find somebody 4 miles away who generally matches the description of the person in the paperwork that was found in the truck. And the officers who find this person, not the trooper, but several other officers who find this person who matches the description, immediately draw guns and they start calling out the person's name. And I've taken a little transcript of the record here and put some audio behind it, and you can turn up your computers to hear the sound on this.
North Bend Creek and Water Lily. Come here. Put your hands on my car. Put your hands on my car. Put your hands on my car. Yeah. All right, put your hands on my car. Put your hands behind your back right here. Guys, share one today. Why'd you run, man? You're scared you're gonna get in trouble? Brother, it was just a car accident.
All right. So a couple of things going on here. Number one, the person who saw him, the trooper who saw him make a bad lane change and then evade in a motor vehicle, that's not the same law enforcement officer who found him and is talking to him here. 2 separate law enforcement officers, and this police officer who's doing the stop at gunpoint with backup officers. The first thing he asks is, he mentions the person's name. I left the person's name out because he's a client, but they said, "You're this person, right?" And the defendant responds, "Yes." So we have some information here identifying him as the person from the paperwork who was in the truck, who was potentially driving the truck. It looks like they've got a connection there, but they want more. They ask, "Why'd you run?" And he says, "I don't know, scared." And he says, the officer says, "You were scared, you were going to get in trouble." And the defendant says, "Yeah." So now they've got a pretty good connection between the person that they've detained and who they suspect is the driver of that truck that fled in a motor vehicle. So we have a couple other things that are going on here that are important, and I wanted to talk about them. The first thing is that the defendant was ordered to put his hands on the car, and he was placed in handcuffs. And we're going to talk about this in terms of custody and what custody means in terms of Miranda. It doesn't always mean that you're under a formal arrest. It doesn't necessarily mean that you're incarcerated in a jail or prison. Custody has a very unique, special meaning under the Miranda law. And in this case, you're going to be looking for factors, questions that maybe support the determination of whether a person's in custody. And this is going to be important. We're going to talk about custody and the types of questions that get asked, because not every detention is going to rise to the level of custody, and not every question is going to rise to the level of a question that was made to elicit an incriminating response. We're going to look at custody right now in this case. He was ordered to put his hands on the car and he was placed in handcuffs. And remember, when the officer was talking on his radio, he said, he reported, "Got him detained." And so the question at this point is, would a reasonable person have understood that his detention was no longer likely to be temporary and brief? And in that particular situation, it seemed very much so like this defendant was not going to be released anytime soon. This was not a temporary and brief detention. And would a reasonable person have believed that his freedom of movement was restrained to the degree associated with a formal arrest? So they didn't use the magic words. They didn't say you're under arrest, but they've got him in handcuffs. They got guns drawn on him. There was backup officers, and they had him over putting his hands on the car. It just didn't look to me, or I think anyone else would think, that this person was going to be leaving anytime soon or excluded from the crime. Well, the officer now brings the suspect, the defendant, back to the house where the trooper is waiting. And now the trooper starts talking to him, and they've already had some conversations, the police and the trooper. They know that he's already admitted the offense. And after a few minutes go by, the trooper says, "I'm going to read you your rights." Well, here's stage 2 of the 2-step interrogation technique. They've already gotten an admission, an incriminating confession. Now they're going to read Miranda and clean it up. And after just a few preliminary questions about what kind of offense this is, the trooper says, "So here's what I want to know. Why'd you run?" He's now taken the statement from the pre-warned questioning and used it to confront the suspect in the post-warning statement. So this is what's going to be very important when you're looking at these cases. The defendant was confronted with his pre-warning statement and then made several incriminating admissions during the post-warning statement. And what he said to the trooper on this second statement was that, in fact, he was the driver and that he evaded in a motor vehicle. He ran because he was scared, and he admitted to hitting the house. He said he ran on foot, and he also made several other false statements about evading, try to avoid consequences and give explanations. But in this case, they finally start talking about charges and the range of punishment. So you can see that that first unwarned statement was used later in the second post-warned statement to try to extract a confession, despite the fact that Miranda warnings were given. Well, I wanted to look at the question, because even though it seems to me that he may have been in custody, the second part of whether or not the question itself was elicited to obtain an incriminating response was also important. So the question was, "Why'd you run?" And he said, "I don't know, scared." And I started reviewing the cases throughout the country to see if that question, especially in an evading case, it seemed to me that that would be a normal question that an officer would ask somebody after they stopped and detained their suspect. "Why'd you run?" I wanted to see if other cases had dealt with that. And sure enough, over the course of the years, you'd find lots and lots of cases in evading where officers would ask, "Why'd you run? Why did he run?" Why? And just basically asking them point blank, without any Miranda warnings, what the reason they ran was. And courts have found that sure enough, that was a question elicited to obtain an incriminating response. So you have to have custody, or something that looks a lot like custody. It doesn't necessarily have to be a formal arrest, and we'll talk more about that in a minute. And you have to have a question that was elicited to obtain an incriminating response. So I'm going to talk more about this. I'm going to talk about some of the reported cases that came out, and I'm going to talk about the 3822 warnings and what it means to be in custodial or custody and custodial interrogation. By the way, throughout the presentation, I'm going to be talking about 3822 warnings and Miranda interchangeably. Miranda, as everybody knows, was a big U.S. Supreme Court case that required warnings to be given. Article 3822, the Texas Code of Criminal Procedure, is the listing of those questions, the listing of those warnings that must be given to a suspect who is in custody prior to the questioning being done, prior to the incriminating responses. So we're going to talk about the warnings and what custodial interrogation means. And we're going to talk about questions intended to elicit an incriminating response. We'll talk a lot more about this 2-step interrogation technique. And we'll talk about some practical ideas for your hearings, for your pretrial hearings, and for trial. So let's talk first about Texas Code of Criminal Procedure 3822. And in there, you'll find in section 3A that no statement of an accused made as a result of custodial interrogation shall be admissible against the accused, unless the accused is given the following warning and the accused knowingly, intelligently, and voluntarily waives any rights set out in the warning. So I want to stop there. 3822 has its own exclusionary rule. So you absolutely need to cite to that along with 3823, but don't leave out 3822. These statements cannot be used unless Miranda warnings are given. But something that gets overlooked a lot in these Miranda warning cases is that the police, especially out in the field, are reciting the warnings to their suspects, but they're leaving out the last part. They go through the whole litany of Miranda warnings, but they don't ask their suspect if they're willing to waive those rights and talk to me. If they don't waive those rights, then the whole point of Miranda is missing and the warnings are ineffective. So be careful, look at the warnings, don't just assume that they were being given properly, and make sure that the defendant says that he's giving up those rights and he understands them. The key here is whether the statements were voluntary. So what are these rights that are being given up? I'm going to talk about the ones having to do with custodial interrogation under the Fifth Amendment. And the first one is that the client has the right to remain silent, and any statement he makes may be used against him in court. We all are familiar with that. That's in the plea paperwork that people sign every time they plead in court. But this is prior to ever having been brought into custody, or I should say, as when a person is in custody, these rights have to be given before any questioning takes place. And he has the right to terminate the interview at any time. And that's going to be important as well, because if a person doesn't feel free to stop the interview, not just at the beginning by saying, I don't want to talk to you, thank you very much, but somewhere in the middle before he incriminates or she incriminates herself, it can be done at any time. So let's talk about some cases that deal with the issue of custody. Custody, according to our cases, exists if an officer makes a formal arrest, which is accompanied by informing the detainee that he's under arrest. And in every DWI video I've ever watched, there's a point after the initial detention where the person is placed in handcuffs and the officer simply says, I'm placing you under arrest. Well, that's a good marker to know when formal arrest occurs. But as we're going to see, that's not necessarily where custody necessarily begins. But in general, these temporary detentions are not custody. A non-arrest field stop for investigation is generally not sufficient, nor is a traffic stop made to issue a citation after which the motorist will be released. So in general, we have a rule that police conduct during an encounter may cause a consensual inquiry to escalate into custodial interrogation. Just because the officer says this was a temporary stop, a temporary detention, an investigation to exclude people as well as find our suspect, our culprit, it may start out as a temporary detention and work its way into custody. So the courts have told us that custody may arise if a defendant is not free to leave or cannot require the officer to leave. It's an interesting way to put it because we always often think of our clients on the side of the road and not being able to leave and not telling the officer that they're dismissed, although I've had some clients try to do that. But if you're at home and the officer tries to come and knock on the door and ask you some questions, custody may arise if the client cannot simply ask the officer to leave. Another component is that the restraint is comparable to a formal arrest. So if your client can't leave, if his freedom of movement is restrained to the extent that he cannot leave, that would be custody. So the leading case here is Douthit. It's a capital murder case. The defendant came to the sheriff's office to give a written statement. And while he later became a suspect and was accused and convicted, Mr. Douthit, when he first came in, was not a suspect. He was just a witness giving a voluntary statement to the police, in this case, the sheriff's office. Well, the court paid a lot of attention. Douthit is a court of criminal appeals case out of Texas, and it's from 1996. The court mentioned and spent a lot of time talking about the length of time Mr. Douthit was there with the sheriff's department, the sheriff's office. He was there being interrogated for 15 hours. And during that time, the sheriff's department, the sheriff's office had exercised a lot of control over the defendant. They had accompanied him to bathroom breaks. They ignored his request to talk to his wife. And while he did not admit to committing the murder, he made several damaging admissions during the course of his interrogation. And in that case, the Court of Criminal Appeals said that custody began after Mr. Douthit admitted his presence during the murders. He was in custody at that point, but had not been Mirandized. And so to give you a visual of what this timeline looks like, 9 o'clock, he comes into the sheriff's office. 2 hours later, he makes his first statement, no Miranda warnings. Then at 1 p.m., he left at 11 a.m. and he goes out for lunch, comes back and says after lunch, you know what? I think I need to make a few more statements. That first statement I gave you, that wasn't completely accurate. I gave you a false alibi. By 6 p.m., he's making his second statement. No Miranda warnings given. He starts at 9 a.m. Now it's 6 in the evening. And at 7 p.m. for the first time, he is asked if he would do a polygraph, and he is given Miranda warnings. Now, that's a long time to wait to get your Miranda warnings. He's already finished 2 statements, and now he's about to work on another. So at 1 a.m., the detective tells him, you were there, though, weren't you? The scene of the murder. And soon after that, the defendant admits, yeah, I was there the whole time. And he gave lots of details about what he observed in the crime scene, but he didn't admit his participation. And he says, well, I was there, but I didn't commit the murder. And the detective says, well, okay, now you do realize, and you knew this going in, you're not going home tonight. You know that. And the defendant replies, yeah, I've known that for a long time. Finally, at 3:55 a.m., 15 hours later, he writes a third statement, but that third statement doesn't come in, doesn't get used against him because it wasn't electronically recorded. But this interview started at 9 a.m. in the morning. It doesn't get done until 3:55 a.m. the next day. And the court said, that's custody. It was comparable to a formal arrest. They did mention, and courts have repeated this, that the subjective intent of the police and the defendant about whether custody occurred is irrelevant, what they intended. Later cases are going to call this into question, but the case law does say that their subjective intent is not relevant. And Douthit said, okay, this was a 15-hour interrogation. They did not Mirandize. The defendant admitted that he was present. He denied that he committed the murder. But the court still said, you know, this is custody and it's not right. Miranda is supposed to be given anytime a person is being questioned who's in custody, and the police just didn't do that. They looked at a couple of situations. They looked at when the suspect is physically deprived of his freedom of action in any significant way. Well, those accompanied bathroom breaks, not being able to talk to his wife, those were all significant deprivations of his freedom. They also said the officer tells the suspect that he's not free to leave, that he cannot leave. That's a factor to look at, and the officers did that in this case. A third factor was that the freedom of movement had been significantly restricted over that long period of time. With all of the other restrictions, this defendant knew that he was not leaving, and the officers told him that. But it's the fourth factor in Douthit that's really important here. When law enforcement manifests to the suspect that they have probable cause to believe that he is guilty of the offense. And in Douthit, they told him that they thought he was there repeatedly and told him that he was not going to leave. So this manifestation, this manifesting the probable cause to the suspect is going to be really important, and it should be mentioned in any motion or any argument you're making at a hearing. But in Douthit, they remind us that there's no bright line rule about when somebody's in custody. And that's helpful, and it's not. It's helpful because we get to be advocates. We get to argue that the circumstances in a particular case do rise to the level of custody. It's not helpful because a judge can pour us out and say, no, I just don't think that meets the standard, whatever the standard might be. But the court tells us that the determination of custody must be made on an ad hoc basis after considering all of the objective circumstances. And they give us examples of when it's not custody. A station house where there's questioning and the person maybe makes some incriminating statements, in fact, maybe leaves at the end of the interview, is not necessarily custody. It doesn't necessarily constitute custody. It might be, but you have to look at all of the factors. Similarly, custody does not occur merely because a suspect submits to a polygraph and fails the polygraph. That doesn't mean he's necessarily in custody. And maybe most important of all, when a person's put in handcuffs, that doesn't necessarily rise to the level of custody. So it seems maybe like a person whose hands are cuffed behind their back and is being restrained to a significant degree is in custody, but not uncommon for the police to use handcuffs and detain people, sometimes dangerous people, until they can exclude them and let them go. So handcuffs don't necessarily by themselves rise to the level of custody. One of the interesting factors I thought that came out of this is that when the officers are not actually conducting an investigation after seizing a suspect. So sometimes you'll see the body cam, you'll see the dash cam, and this is probably a good point along the way to mention, since we've started getting volumes of video on every case, sometimes 8, 9, 10, up to 12 body cam videos and dash cam videos, there's a lot of police chatter that we need to listen to. And it's going to indicate whether or not these officers are actually investigating the offense or talking about what they're going to do when they get off a shift, or what they're going to do tomorrow, or what their family's up to, or some other personal stuff that has nothing to do with the case. So look at that. If they have your client detained, but they're not really investigating anything having to do with the case, that may be custody. That may not be a temporary detention. Also, the court's made a point that custody does not necessarily occur simply because someone is incarcerated or confined in a county jail. If they come by and they're investigating a crime and they let the person know that that's what they're investigating, they need to Mirandize. But just because a person's in jail doesn't necessarily require Miranda unless they're investigating some other case. That person would be in custody for purposes of Miranda. So Douthit took 15 hours, and that's a little discouraging because most of our detentions don't last that long. But lots of them do last no more than 10 minutes, and those were the facts in State v. Ortiz. This was a drug case, a POCS, and the way this case got started looked a little iffy to me as I was reading it. But during this case, the driver got pulled over for going 13 miles per hour over the speed limit. He was speeding, and within 10 minutes of the stop, he gets accused for having drugs. Here's how that happened. After asking for the license and insurance, the officer told the defendant to step out of the vehicle. By the way, no evidence of drugs at this point, just driving 13 miles over the speed limit. The officer questions the defendant, and the defendant revealed to the officer that he was going to Sherman, Texas with his wife, and that in fact he was on probation in Sherman for drugs. Well, that aroused the officer's suspicion a little bit, and the officer asked point blank, how much drugs are in the car? And the defendant responds, no, no, no. All right, so the question is, at this point, is he in custody? Probably not. Probably not, but maybe. He responds no, and then he consents to a search of his person and his car. Well, 2 more officers arrive, and they have his wife step out of the vehicle. And they pat her down and they put her in handcuffs, and they discover drugs during her pat down. So the officer immediately finds out about this, and he turns to the defendant and he says, yep, turn around, put your hands behind your back, and he handcuffs the defendant. The officer asks the defendant, what kind of drugs does your wife have? And he responds, cocaine. And this leads to a charge of POCS, more than 400 grams of cocaine. Looks like a pretty routine traffic stop, but the court looked at this and said, no, motion to suppress granted. By the time the defendant was placed in handcuffs, he was arrested and in custody for Miranda purposes. It's a little bit shocking. We see cases like this all the time. And I think Ortiz is a great example of why you need to be looking at these cases more closely. They looked at all of the factors that were brought up in Douthit, that the arresting officer had expressed a suspicion that the defendant point blank had drugs in his possession, that there were backup officers, that they were patting down and searching his wife and putting her in handcuffs. But what was most important to the court was that fourth Douthit factor, that the officers had manifested their belief that the defendant was connected to some sort of illegal or dangerous activity on the part of his wife, that he was in custody, that these circumstances combined to lead a reasonable person to believe that the defendant's liberty was compromised to a degree associated with a formal arrest. That just happened in a couple of minutes. So you don't have to wait 15 hours. Custody can occur anytime the officers manifest their belief to the defendant that he is connected in some way to criminal activity. So look for that. If they make that statement and your client is being detained, maybe that detention rises to the level of custody, and maybe you can keep out his statements and everything that flowed from it. The next case I want to talk about having to do with custody is State v. Signs, and it's a DWI, it's a drive-through, and of course, it's at Whataburger. So State v. Signs is a case that started in the Corpus Christi Court of Appeals. It went up to the Court of Criminal Appeals, and then it got remanded back down to the Court of Appeals in Corpus Christi. And they found that the statements that this DWI driver made were made while he was in custody. And I point this out, the timing isn't everything. Ortiz and Signs are cases where the detentions turned into custody very quickly. 12 to 18 minutes in this case, where the detention rose to the level of custody. So as I mentioned, this was at a Whataburger, and there were two intoxicated men who were trying to start a fight. That's what the 911 call said. And when the police get there, they see the defendant sitting in a truck. There's another guy in the truck. They're parked across a handicapped parking space. The engine's running and the reverse lights are on. While the defendant and his passenger match the descriptions that were made by the 911 caller, and the patrol officer told the defendant on 3 occasions, hey, turn off your truck, get out of the vehicle. Defendant's not being very compliant, but finally he does shut off his truck, and the patrol officer removes him from the vehicle. They don't put any handcuffs on him, and they put him in the back seat of a patrol car. And that's where the defendant waited for 12 to 18 minutes before the DWI task force unit came to interrogate him. Patrol officer took him out of his truck, put him in the patrol vehicle. He can't get out. The patrol car is locked, couldn't leave. Then the DWI unit comes and they start with questioning. No Miranda warnings were given. The officer asks all the typical questions we always hear on DWIs. Where had you been? How did you get here to the Whataburger? How much alcohol had you consumed? Where did you consume it? And how long have you been drinking? And sure enough, defendant responds. He's not been warned. He says, yeah, had 6 beers in 4 hours. That's an incriminating statement. That's the essence of that DWI. That is a confession, more important than DNA, more important than fingerprints, more important than eyewitnesses. Once a jury hears that the person confessed, well, there won't even be a jury because that case isn't going to go to trial. No one's going to try that case. If they did, your client would be convicted very quickly unless you could keep that statement out. And the court said that the officer's actions escalated the temporary detention to an arrest, and that the defendant was in custody at the time he was placed in the back of the patrol car. Nice. Court went on to say, for the reasons given, the trial court did not abuse its discretion in concluding that the defendant was in custody at the time he made the statements or in suppressing those statements. Great. So now we have a pretty good idea, some idea of some examples of when a person might be in custody. In Douthit, it was a very long interrogation where his freedom of movement was significantly restrained. In Ortiz, the officers manifested their knowledge, their intent that there was probable cause to believe that the defendant committed a crime. And in this last case, in Signs, the defendant was seated in the backseat of a patrol car in just a matter of minutes. He gave incriminating statements while there, again, was probable cause to believe that he committed a crime. Never warned. And his post-Miranda statement, his statement prior to warning would be used against him. But it turned out that the court said no, he was in custody, and those statements couldn't be used. So let's take a brief look at interrogation. And for the most part, the courts tell us what is not interrogation. A question that is made during custodial interrogation needs to be reasonably likely to elicit an incriminating response. Anything that your client says while being detained or even in custody that's not in response to questioning is voluntary, and it's not barred by the Fifth Amendment. It's not protected by Miranda. Even after you've been Mirandized, if a person volunteers incriminating statements, they may come in because volunteered statements are not in response to incriminating to custodial interrogation. So Miranda does come into play whenever a person in custody is subject to either express questioning or its functional equivalent. An interrogation refers to any words or actions that the police should know are reasonably likely to elicit an incriminating response from the suspect. So what is not interrogation, what is not going to be considered reasonably likely to elicit an incriminating response might include routine inquiries and questions incident to booking. So your client's being brought into booking and typical questions, he's obviously in custody. Typical questions are, what's your name, date of birth, where do you live, where do you work, tattoos, jewelry, any other marks on you. Those type of routine questions are not going to be considered protected by Miranda. Also, broad general questions such as what happened on arrival at the scene of the crime, or questions mandated by public safety concerns, like where did you hide the weapon? Asking a suspect whether he would take a breath test or a blood alcohol test is not going to be considered custodial interrogation. Similarly, where are you going? Asking that of somebody who's just walking down the street is not going to be custodial interrogation. And where's the murder weapon? Cases say that that question was not custodial. It did not rise to the level of custodial interrogation. So be careful. Look at the question, look at the answer, see if it fits what the cases are talking about. And Article 3822 applies obviously to law enforcement. It does not apply to non-law enforcement personnel who are not state agents. So this is important because a lot of times our clients talk to other people about cases or their case, and they want a response. They want to know, what do you think? What do you think about this? And if they make a voluntary statement, well, that's not protected. But if they make these statements to a probation officer or a CPS worker or a teacher or anyone else in response to questioning, no Miranda warnings need to be given, and they cannot later claim that they didn't know that they had a right to remain silent. So who are some non-state actors? Well, television reporters who interviewed your client, even in jail at the behest of the police, are not state agents. No Miranda warnings need to be given. And doctors and nurses who the defendant make incriminating statements to while being treated at a hospital are not state agents. No Miranda warnings need to be given. And you might think that this is at cross purposes with other rules of evidence, such as, the rule about medical testimony and statements made for purposes of medical diagnosis. A lot of times doctors, nurses have to find out what happened when they're treating people. And if your client makes a statement about what happened and incriminates himself, that statement may be admissible. These are not state actors. However, Wilkerson was an interesting case because that one involved a CPS investigation. And CPS investigators may in fact be state actors. They may be agents, but they may not. In this case, a CPS investigator met with the defendant while he was in the county jail. And she interviewed him and asked him a bunch of questions about the marks that were found on his son. And the defendant said, yeah, he used corporal punishment. He had spanked his son several times. And that statement came in at trial. And the jury said, yeah, guilty. He was convicted of causing serious bodily injury, and he was assessed punishment at 30 years in prison because of the statements that he made to a CPS worker. But Wilkerson looked at this case a little more closely, and they said when a state agency employee, a CPS worker, is working on a path parallel to yet separate from the police, Miranda warnings are not required. It's only when a CPS investigator or any other law enforcement state actor or state agent is working in tandem with the police to investigate and gather evidence for criminal prosecution that such warnings are required. So think about that, because it's not unusual for CPS workers to be using the same police report that the police are using on the criminal investigation. It's not unusual for them to talk to each other. When it becomes a problem is when the police offer questions to the CPS worker to go in and ask the defendant to see if they can get an incriminating response. At that point, they might be working in tandem. So this might apply to a CPS caseworker. It might apply to a teacher, a preacher, a probation officer, or any friend of the family. And think about this. When your client is on probation and he has a probation officer, one of the rules of probation is that he has to report any subsequent offense to his probation officer. Probation officer does not have to give him any Miranda warnings. And so if your DWI client on probation is being looked at for murder, he may have to think real hard about whether or not he's going to violate his probation and talk about this murder case with his probation officer or choose to remain silent. So I wanted to talk about the two-step questioning technique after we've now talked about custody and interrogation. I want to come back to this idea of two-step questioning and look at how the cases have interpreted this. Sometimes called the question first, warn later technique. And as we've been talking about, if the police question the suspect first and then give Miranda warnings, they've engaged in a two-step or question first, warn later interrogation. And the leading case on this is Missouri v. Siebert. It's a U.S. Supreme Court case from 2004. And in it, the court concluded that a question first, warn later interrogation technique circumvented the objectives of Miranda by rendering any warnings given ineffective. The facts of Siebert are really interesting. This was a Rolla, Missouri Police Department that made a conscious decision to withhold Miranda warnings. It wasn't just a conscious decision. This police department had a protocol to do a two-step technique. They were trained on it. They were told to do it so that they would get unwarned statements, Mirandized, repeat, and get an incriminating statement after the person was Mirandized. And that way they could claim the statement was voluntary. The officer in this case questioned Ms. Siebert for 30 to 40 minutes. And prior to Miranda, Ms. Siebert admits that she knew her son was meant to die in a house fire. Well, there's the incriminating statement, the pre-warned statement, and the officer gave her about a 20-minute coffee break. And after the break was over, he came back into the room. He Mirandized her, gave her the warnings. He obtained a signed waiver, and he confronted her again with her pre-warning statement. And this was important, the police confronted her with her pre-warned statement. They said, didn't you tell me that he was supposed to die in his sleep? Didn't you tell me that? They did that 3 times. And finally, she breaks down and she says, yes, I knew it. I knew that he was supposed to die in that fire. And her statement was largely a repeat of the information they obtained pre-Miranda. The Siebert plurality in that case found that the purpose of this interrogation technique was to obtain a confession that the suspect may not have made if she had understood her rights at the outset. And Siebert is a plurality. There were several opinions. One of the concurrences talks about a test, and that concurrence gets adopted later by lots of courts, including Texas. And the concurrence actually becomes even more important than the plurality. The concurrence wrote that when a two-step interrogation technique is used in a deliberate, calculated way to undermine the Miranda warnings, absent curative measures, the post-Miranda warning statements must be excluded. So let's look at what they're talking about here. It's a two-step, two-stage interrogation technique. Step one, get a statement without any Miranda warnings. Step two, give the Miranda warnings and then have the client repeat the statement so that it appears to be voluntary. The court in the concurrence mentioned that whether the police do this in a deliberate way, in a calculated way, is important. If it was just a rookie mistake or a good faith mistake, we might be willing to overlook that in some circumstances. And if the police use curative measures after doing this two-step technique, maybe the statement will come in even though they violated Miranda. And what they talk about as far as these curative measures include maybe taking a substantial break. For instance, if a couple of days go by after the first statement and then the person comes back in and they are Mirandized and they give another statement, well, the court at least believes maybe that gap in time was sufficient to let the person know they didn't need to go on and make an additional statement, and maybe they would assert their right to remain silent. Another curative measure would have been explaining that the unwarned statements are likely inadmissible. So if the person gave two statements, they get Mirandized midstream, and then the officer says, by the way, anything you told us before in that prior statement, we're not going to use. That might be a curative measure. Another curative measure might be informing the suspect that he's not obligated to repeat the unwarned statement. A fifth one was that the defendant is not obligated to discuss the first statement at all. So these curative measures might be a way for the police to do an end run around the end run of circumventing Miranda. But lots of cases have said, no, the curative measures didn't work. Lots of cases say that although they did a two-step interrogation technique, and there may have been some good faith on the part of the officers, we're not going to let them slide. So again, with all of these rules, they are very fact dependent, and that bright line that we sometimes have in deciding whether somebody has gone too far in obtaining an inadmissible illegal statement is up to real good advocacy. So you want to look at your facts, you want to look at them carefully and decide whether or not this is something that you can argue for your client. It's important to remember too, that if they use this two-step interrogation technique, it's not just the first statement that gets excluded. That first statement is what got used to extract a second warned statement. And the courts have said that if this happens, suppression of both the unwarned and the warned statement is appropriate. So how do you fight these cases? One thing you got to do is do your work on discovery up front and get as much information as you can. Find out what the statements are, what the questions are, and you got to file a motion to suppress, and it's got to be very, very precise. The Court of Criminal Appeals in Texas said it's not enough to contest the voluntariness and the compliance with Article 32. You've got to go and take the extra step of saying this was a two-step interrogation procedure, and it was done illegally, and it was done with the intent to obtain an unwarned statement to be used later and obtain a warned statement to follow. In Vasquez, the court said that the appellant's objective was too imprecise to put the trial court or opposing counsel on notice as to the legal basis for the objection, and consequently, the appellant's objection was not sufficiently specific, and that the appellant did not preserve his two-step interrogation complaint for appeal. So be specific, be precise, put as much fact and detail in your motion to suppress as possible. And then in your motion, quickly establish, number one, that your client was in custody or something that rose to custody. Maybe it was formal arrest. Maybe during the detention, it changed and the police manifested probable cause to your client. Maybe your client's ability to move, his freedom of movement, was restricted sufficiently to the extent that it rose to the level of custody. So look at the facts and allege that he was in custody. Look at what law enforcement asked. What were the questions? Were they reasonably likely to elicit an incriminating response? Make sure to distinguish the questions from routine booking questions or questions that the court has in the past said don't rise to the level of questions reasonably likely to elicit an incriminating response. Identify the specific questions and pre-Miranda and post-warning statements. And I highly recommend getting a court reporter to take down the video, those parts where you feel like the police just violated your client's rights, and attach that to your motion. Attach a copy of the video to your motion as an exhibit. And by the way, if this is, if you just don't have funds to get a court reporter to do that, there are lots of services out there now where you can take audio recordings and have them transcribed for next to nothing. And you can clean up those audio transcriptions, the transcription itself, and attach those to your motion, or just take excerpts and put them in your motion. They have timestamps, just makes your argument a lot easier to follow when the judge or the prosecutor is saying, now, where exactly did this happen? So you want to get your recordings, you want to attach video, cite to the police reports, get witness statements, do whatever you can to nail down what happened. Because a lot of times the pre-Miranda statement may not even be recorded. You're just going to have to find a way, if it's not recorded, to get that into your record. And then find the point at which the officers confront the defendant with his pre-warned statement to try to extract the second statement. Make sure that you document all the time that passes between the confessions and the change in place of the interrogations, and whether or not the interrogators themselves changed. In that motion to suppress, you want to allege that Article 3822 warnings weren't provided, or maybe were deficient. Maybe they didn't ask for that waiver at the end. Maybe they skipped through them and didn't mention that the defendant has a right to refuse to answer questions. You want to allege that the defendant's statements were the result of a deliberate two-step interrogation process. And while you might not have a protocol in the police department or a manual that talks about it, you might be able to find other officers who are willing to talk about it. You might find that it's obvious from the way that the interviews happened that this is what they were doing. And don't rely entirely on whether or not it was deliberate or not. If they didn't give Miranda warnings, argue it was deliberate. Any trained officer, anybody with experience, is going to know that they have to Mirandize someone who is in custody. And if they didn't do it, it may be important to your judge. It may be important to your prosecutor. That deliberate factor, that's a scale. It's a range. Who's to say exactly what is meant by deliberate? So definitely allege it in your motion and find facts to support it, but don't feel daunted if you can't find anything very specific. The fail to warn was calculated. Make sure that the judge and your prosecutor know that it was deliberate, that it was not in good faith, that it was not merely an oversight, and that shouldn't be an excuse. Examine the explanation that the officers gave and the failure to provide the warnings. Why didn't they do it? If the person was being detained and it looked like this person was going to be in custody, maybe they were. And why didn't the officers give the warnings, give the Miranda warnings, 3822 warnings at that time? Think about whose burden of proof it is. the courts say very specifically that when Miranda warnings are delivered in a two-step or midstream procedure, the government, the state bears the burden of proving that the police did not deliberately withhold the warnings. I would probably raise that in my motion and raise it during a hearing, but I think it's important to point this out to the judge, to the fact finder, that it is the state's burden to prove that it was not deliberate. And then you want to talk about the curative measures. Make sure in your motion that you talk about how there were no substantial breaks between the post Miranda warning and the pre-Miranda warning statement, that there were no additional warnings provided. And as best you can, identify in your motion the times of all relevant circumstances for the trial court. You're going to want to make sure that you cite to the appropriate authority, and you're going to want to cite to the 5th, 6th, and 14th Amendment. You're going to mention Article 1, Section 10, the Texas Constitution, Article 3822, where all those Miranda warnings are found, and 3823, the exclusionary rule. Make sure you put those in the motion, and then cite to the cases. You want to cite to Miranda, to Siebert, Martinez v. State, which is a Texas Court of Criminal Appeals case, Carter, another Texas case. And for an excellent read on all of this, you're going to want to take a look at U.S. v. Capers. It's a Second Circuit case. The site is 627 F. 3rd 470. It's a 2010 case. And Capers goes to lengths to talk about how deliberateness may be a factor, but it's not a very strong factor. And when Miranda warnings are not given, they're going to presume that that was deliberate. So if we come back to the case that I started talking about, the one that got me all interested in this, the one where my client struck a house, how does this case fall under the rules that we've been talking about? Was he in custody? Were the questions designed to elicit an incriminating response? Did he give an incriminating response? Did the officers act deliberately? Were there any curative measures? Well, I argued that this was a two-step process. And when the prosecutor had to look at my motion and talk to me over and over again about this case and realized how much work it was going to be for him to get schooled on this Miranda issue and start looking at all those videos, things changed very quickly in our discussion. The defendant had 3 prior evadings in a motor vehicle, and the offer in that case was 5 years TDC. We had to talk about whether he was in custody. I thought he was. Whether the interrogation was likely to elicit an incriminating response. It clearly did. Whether or not the officers acted deliberately and used a 2-step questioning technique, it was definitely a 2-step questioning technique. Deliberateness was going to be an issue. There really weren't any curative measures in this case. And the result was that the prosecutor came down to a misdemeanor evading and offered him 2 years probation. So I think these issues can get you great results. I think if you litigate them, we're eventually going to see some good law get made. Miranda is alive. I would encourage everyone to go out there and litigate these issues. And if I can be of any help in handling these cases, please call me. I'd be happy to do it. Thank you very much.
Excellent. Thank you, David. I learned a lot. We did have one question. Did you have the site for the case that you gave? Was that in your notes, maybe?
The case at the end, I can get you that screen.
Thank you. There's our case sites.
And I'm happy to share the presentation, which has lots of annotations and other case sites as well.
Okay. Well, thank you, everyone. I'm going to go ahead and put up our CLE number. Remember, CAPS will take care of your CLE reporting if you're watching live. If you're watching this recording, make sure you go ahead and enter in your CLE. So thank you so much, David, for coming on today. It was a great presentation. We really enjoyed it. And let me know if you have any questions. This recording will be available next week on the listserv for anyone who wants to access it again. So
Have a great weekend, everybody.
thank you, everyone. Take care.